Hello, Dubai. Is anyone there?
Good morning, Your Honour. It's Tom Montague-Smith here for the claimant.
Oh, good morning, Mr. Montague-Smith. Do we have anyone else online?
Good morning, Your Honour. This is Jitendra Vadhwani from Emirates NBD.
Morning, Your Honour. We've got Alex Clayman and James Ironmonger from DLA Piper.
Thank you. Thank you, Alex Clayman. I beg your pardon.
And James Ironmonger from DLA Piper.
Thank you, Mr. Clayman.
Good morning, Your Honour. Sorry, that for the claimant, those are my clients and my instructing solicitors. So in terms of advocates, you've just got me, I think, at the moment, no one for the defendant yet.
Right. Thank you very much.
Thank you.
Apologies, Your Honour. This is Tim Taylor for the defendants. We were muted, I think. Can you hear me now, Your Honour?
I can, thank you. Can you hear me?
I can. Well, Your Honour, thank you. Apologies for being on mute. I am here, it's Tim Taylor, QC, with my colleagues Joanne Strain and Brendan Palmer at King & Wood Mallesons.
Thank you very much. All
Good
right,
morning, Justice Giles. Yeah, it's Maytha here. I would like to begin by reading out a statement.
Thank you, Maytha. Go ahead.
Thank you. The hearing on this application is being heard in the DIFC courts in Dubai. Although Justice Roger Giles, the judge hearing this application, is appearing by way of teleconference from Australia, any orders or directions made after or during the course of this application will be issued by the registry in Dubai on Justice Roger Giles' instructions. Will the judge and parties' representatives please confirm that the situation is as I have stated? Thank you very much. We are here for a hearing in the matter of CFI 037-2020 before Justice Roger Giles. The claimant is represented by DLA Piper Middle East. Lead counsel is Tom Montague-Smith, QC. The defendant is represented by King Wood Mallesons. Lead counsel is Tim Taylor, QC.
Well, gentlemen, I have read the witness statement of Mr. Murhi, the defendant's outline and the claimant's note. So you can take all those as read. Mr. Taylor, I think over to you.
Thank you, Your Honour. As Your Honour will have seen, this application is made seeking an amendment to Your Honour's order of 4th June. Does Your Honour have we have a trial bundle? I don't know what form Your Honour has it, but you have the application notice and the draft order.
I have the application notice and the draft order. I have a link to other materials which came together with Mr. Murhi's witness statement, but if there's occasion to refer to them, it will be necessary for me to open the link and find my way through it.
I'm grateful, Your Honour. We have also exchanged some authorities, and I think the latest thing that will be a link to one or two further authorities that I may need to refer to, in particular the Dubai mortgage law, to which, as Your Honour's judgment records at paragraph 4, the mortgage as extended to the 30th of June 2020 was said to be subject. Now that is the Dubai mortgage law number 14 of 2008, which is the onshore Dubai mortgage law. in addition, for context, I have just put in the predecessor DIFC mortgages law of 2007, which was repealed and replaced by the 218 law under which Your Honour has made his judgment in terms of the foreclosure would take effect under the current legislation. So, Your Honour, the defendant's case is that the agreement between the parties is subject to arbitration. It was made so subject in the Common Terms Agreement and allied documentation, which was before Your Honour when the application was made on the 4th of June. I don't know whether Your Honour, it's probably difficult to find that document, but the relevant provision in the Common Terms Agreement is clause 38, which provides that the deed and any non-contractual obligations arising out of or in connection with it will be governed by English law, and it contains in it the governing law of the agreement is also English law. I think there's no issue between the parties about that. Indeed, that was recited in the witness statement of Jitendra Wadwani, which was before Your Honour when the application, Part 8 application, was made. Amongst the arbitration clause provides for LCI arbitration in Paris, and it extends to any dispute, claim, difference or controversy arising out of or related to or having any connection with the finance documents. And the finance documents are a defined term, and they are defined so as to include the mortgage with respect to which the foreclosure order was made. So, Your Honour, our case is first and foremost that any dispute arising out of or connected with a large suite of documents, because this restructuring, as Your Honour will have seen, was a substantial and complex restructuring in 2014 with multiple parties, both affiliated companies to my client company within the Al Jaber group, and in terms of the both conventional and Islamic finances. And Emirates NBD was a party, and Al RIHAB Real Estate Company LLC was also a party. We say, so that there's no question but that this arbitration clause is operative, valid, and that we say it engages Your Honours and the court's obligation to stay. It's a mandatory stay obligation, and as I'm sure Your Honour will be familiar, where it comes from is fundamentally two places. The UAE is, of course, party to the New York Convention on the enforcement of arbitral awards. It is a provision of the New York Convention that requires signatory states that when an arbitration comes before them, and in this case it's one seated in Paris, so there's no question, it isn't a purely domestic situation where it would be necessary to determine whether or not this was to be treated as an international arbitration. It plainly is. So the obligation to stay is mandatory. The New York Convention is, here in the UAE, we're effectively a monist system. There is no legislative body that would be bypassed if the treaty is contracted by the UAE, automatically form part of municipal law without more. That is indeed the case here, and as I'm sure Your Honour will be familiar, the enabling federal statute, which set up the DIFC as a financial free zone, whilst excluding the operation of UAE civil transactions laws, cemented the obligation of the DIFC courts to uphold the treaty obligations of the UAE. Your Honour, I noted that in your judgment it was said that there was there appeared to be no defence to the claim, or words to that effect. That, Your Honour, is not a reason not to, that the mandatory stay obligations do not apply. It used to be the case in England before we acceded to the New York Convention that if there was an arbitration clause but you had a claim for summary judgment and could get summary judgment on what was then Order 14, is that the court could ignore the arbitration clause by saying that there is no dispute to be referred to arbitration. That is no longer the case. The then Arbitration Act in England was amended to cater for that, and amongst other things, if Your Honour has, and if Your Honour doesn't have, you certainly should acquire as soon as possible Mr. Montague-Smith's and Mr. Reed's invaluable DIFC courts practice. There is reference there to the former Chief Justice, Michael Hwang, when he introduced the novel provision that it is possible, if a DIFC court judgment is not satisfied, that it may be converted into an arbitration award. One of the matters that he had to concern himself with was there a dispute? And in his article on the subject in Arbitration International, he explained in that article that there's a long line of common law jurisprudence establishing, for the purpose of determining whether an issue can be arbitrated, that a quotes dispute quotes exists wherever the respondent refuses to pay or keeps silent, but in any event does not pay. That, for the transcript in Your Honour's note, is on page 166 of Mr. Reed's and Mr. Montague-Smith's DIFC court practice. So we say that this is unquestionably, the mandatory obligation to stay is unquestionably caught, and it's furthermore, it is not accepted that either there is no dispute or that there aren't very substantive matters that require to be referred to arbitration. Your Honour, the way that we say that the contractual obligations fit with the real property rights and the registration requirements that are occasioned is this. There is no doubt that now, following the passage of the original DIFC real property law in 2007, that all requirements for registration for the purposes of the validity of security and all requirements as to the alteration of that register can only be effected through the powers of the DIFC courts. However, when it comes to the laws of civil obligations and contract, what the parties have agreed to do has been subject to arbitration, made subject to arbitration. Accordingly, any gateway to court jurisdiction at the lex situs is via an arbitration agreement, so that any question as to whether there are rights of foreclosure, rights of sale, etc., any impact on all of the other lenders to this group, all of those matters will be matters subject to arbitral jurisdiction. If I may explain so now a slightly curious feature of the way in which this mortgage appears to have been contracted is that, as Your Honour has recorded at paragraph 4 of your judgment, and correctly so, the amendment to the mortgage, which extended it, if your lordship, if your honour recalls, until 30th of June 2020, which is why this matter was urgent on the 4th of June and certainly has not become less so now, is that that reference is to the onshore Dubai mortgages law. Now, what the provisions of that law says, and I don't know, Your Honour, we have sent to my learned friend and to the registry a link with the provisions that we intend to rely upon. But I would draw attention simply to one provision at this stage of the Dubai Law 14/2008, which is that it provides that by Article 31 that the Civil Transaction Code, Federal Law 5 of 1985, as amended, applies to insofar as provision is not made explicitly in the Dubai Law 14 of 2008. The relevance of that to the present situation, Your Honour, is this. Notwithstanding that the chosen law of the parties for the purpose of the refinancing document and the arbitration, etc., is English law, there is a mandatory provision of applicable law in the UAE which is to be found at Article 429, so I beg your pardon, I misspoke, 249 of the Civil Code. This is a hardship provision. It provides that if exceptional events of a public nature, which could not have been foreseen, occur as a result of which the performance of the contractual obligation, even if not impossible, becomes onerous for the obligor, so as to threaten him with grave loss, it shall be permissible for the judge, in accordance with the circumstances and after weighing up the interests of each party, to reduce the onerous obligation to a reasonable level if justice so requires. And then there is the critical bit, is that, and any agreement to the contrary shall be void. With respect to that, sir, if this agreement had been made fully, the mortgage agreement had been made fully subject to UAE law, and it chose the onshore law when made, if it had said, both parties agree that they will make no application under Article 249 of the Civil Transactions Law, that would be void. And in my submission, the same applies where the means by which it has sought to avoid that mandatory provision of applicable law is by an artificial choice of another law. In my respectful submission, Your Honour, also need not trouble yourself with how the disapplication of federal civil transactions laws, which is what the Constitution and the relevant federal legislation says from the UAE, means that there is no need to pay heed to this provision of the Civil Code. That is for two reasons. One, because this contractually, the civil obligations were not made subject to DIFC law. Furthermore, what I would say is that all that is excluded by federal law from application within the curtilage of the DIFC is civil transactions law, a provision which says what parties cannot agree is the delimitation of where private civil transactions law ends and where public law begins. And therefore it is a matter of public policy which trumps private bargain. Your Honour need not be troubled by the DIFC jurisprudence that has endeavoured to deal with this issue, because in my respectful submission, the only law that has been displaced so far as the parties' contractual relations are concerned by the agreement to English law is UAE onshore law. That is made plainer by the fact that the mortgage specifically refers to the 2008 onshore law, when it could, so far as one can see, just have as easily have referred to the 2007 DIFC real property law, which had the predecessor provisions for mortgages within the DIFC. And its preamble explains the background to that. The land, the 112 acres on which the DIFC now sits, along with all other land in the Emirate not otherwise in private ownership, was in the property of His Highness the ruler, who transferred it to the DIFC, and thereon they created a property regime which, so far as I understand it, Your Honour, is a blend of English property law and the Australian system. So there is no question, in my respectful submission, that the arbitration provision is engaged and that the court should not have exercised jurisdiction in the circumstances.
Well, this maybe all have been material on the 4th of June, but I hope you will get somehow to how it relates to the relief which you're asking, which is effectively variation of the orders that were made.
Well, indeed, sir. And I mean, having seen my learned friend's note, the issue that confronts Your Honour and me as an advocate is the question of whether there is power to vary or affect a judgment that was made, as it appears to me, as a final and not as an interlocutory judgment. The order has been perfected, so there is no possibility for the barrel jurisdiction to be exercised, which is the residual jurisdiction to alter judgments after a judgment has been rendered but before they've been perfected. So the question will be whether in circumstances where perhaps per incuriam there was a failure to adhere with the New York Convention, in circumstances where some, as I understand it, and we haven't got a transcript, and as Your Honour will see, we were only able to be instructed. I mean, we were approached during last week. We were only able to read the first document and get the client on board by Thursday. So we've had to move fast. I appreciate fully that that does not excuse the inactivity on the part of the defendant before we arrived there. But what did happen, Your Honour, as I understand it, is that Ms. Fatima Al-Jabbar, who, so as far as I understand, is the daughter of the gentleman, her father, I believe, who is one of the two shareholders of RIHAB, and who does have power of attorney on behalf of it to instruct lawyers. It was his daughter. I understand that she does have a power of attorney from her father. It is in Arabic. We have not been able to work out whether it is effectively a delegation of his powers. So never minding the technicalities as to whether the company was in fact represented, there was someone there who asked Your Honour for an adjournment. Now, I can see that Your Honour was perplexed about the inactivity of the defendant in coming to court here from Abu Dhabi, and I can, doing the best I can, Your Honour, try and picture this. I'm imagining myself as an icon of Australian culture, resident in Melbourne, someone such as Kylie Minogue, who suddenly discovers that the people of New South Wales have turned the Sydney Opera House into an island in which the Arabic language and Sharia law is applied, and then receives a document which has been translated into English, one page of it, accompanied by a massive pile of documents in Arabic. You might imagine that she might be rather surprised that she had to come to answer to all this. But be that as it may, we are where we are, Your Honour. It was also in the holy month of Ramadan that service was effected.
Mr. Taylor, we are where we are, and I hope we are going to move forward from where we are.
Indeed. So how I wish to move forward, because I think Your Honour is fundamentally, I'm going to have two choices. If Your Honour is not persuaded that the relief that is sought here is within Your Honour's power to give because you're functus officio effectively, then we would have to talk about stay, permission to appeal, etc. But if Your Honour is persuaded that in circumstances where if Your Honour is persuaded that I'm right on the first point, that the mandatory stay is engaged, and then what we're coming down to is we are offering what is intended to be a pragmatic solution which serves the overriding interests in circumstances where we are on the precipice of the forfeiture of a real estate interest, which could do irremediable harm, as against a claimant who, I have to say, appears to have been extremely patient to date. Patience may well have run out, but any loss and damage they would suffer is readily compensable in interest, and there doesn't even have to be an argument about the measurement of that. What my clients, having been given by Your Honour's order a possibility, I mean, it was effectively in the form of an order nisi. So what is affected by it is the conditions, the nisi conditions, as it were. They had until the 23rd of June to either sell or repay. In my respectful submission, Your Honour, even the answer to that being a judgment in final form is that the nisi provisions, just like anything else in family law, the conventional way of giving the decree of dissolution is first its nisi becomes absolute, is that Your Honour is not functus at first instance. When something new is put into play that affects the conditionality of the order that has been made, albeit that it is a final order.
Mr. Taylor, there is one thing that is plain, is that was not an order nisi situation. It looks to me like a final order, and I thought that you were trying to say that for some reason it was not. Let me say what I understood your position to be, and maybe we can try and get to Hobbs with it.
Right.
First of all, in the application notice and in Mr. Mehi's witness statement, the submission seems to be that in the exercise of case management powers, I can vary the orders that were made. That, I have to say, seems to have rather fallen by the wayside. Perhaps you could tell me in due course. And instead, you are putting an argument which, in a manner which is yet to be properly enunciated, seems to turn upon your submission concerning an arbitration agreement and a mandatory stay. Those, it seemed to me, are the two areas where you are trying to say that there is power to vary the orders in the way you want. Now, tell me where I am wrong in that understanding.
Your Honour is absolutely right. Is that what was invoked here was case management powers that are undoubtedly there. The question becomes, and to the extent that I am perhaps attacking somewhat on those submissions, is in the light of the position that is taken by Mr. Montague-Smith in his note, in which he appears to take the position, and obviously Your Honour will hear from him, that those case management powers are not available to you because my client is in the position where it should now seek permission to appeal and make an application for stay if necessary. That is not presently before. It was not in the application as made. I freely confess that. But as far as I'm concerned, Your Honour, the case management powers which are set forth in Part 4 of the RDC are at pains to stress that they are wide. 4.2, paragraph 4.2, and I don't know if Your Honour has access online to the rules.
Yes, I can get them. Just give me a moment and I will get them in front of me.
Thank you.
I have Part 4 in front of me now, but let me just see what we are about. Are you submitting that the case management powers in Part 4 give me power to make the orders varying 15th of June orders in the way you seek? Is that your submission?
That is my submission, Your Honour.
All right. Well, perhaps you could address that concisely, and then we can move on.
I shall, Your Honour. So there are two ways in which I can put it. First way, if one has, is that the court has an inherent jurisdiction. International Electromechanical Services and Al-Fatan Engineering is that. Apologies, I can put that in as an authority. But the point about that is that the inherent jurisdiction of a court is a jurisdiction that resides in the court rather than the judge. In circumstances where what is the concern raised is the obligation of the UAE to comply with its international obligations under the New York Convention, I would submit that the inherent jurisdiction of the court permits the necessary variations to make it plain that the order made is subject to arbitral jurisdiction. If that is
an aspect of your argument concerning arbitration.
That is indeed.
What I thought you wished to put was a freestanding argument that the case management powers themselves give power to make the variation orders that you seek. Am I right or am I wrong?
You're right about that, and that's the second way in which I put it squarely under the rules, under 4.2.
Well, for heaven's sake, please, Mr. Taylor, say what you need to say about that. So
under 4.2.14, set where the rules provide otherwise, the court may take any other step or make any other order for the purpose of managing the case and furthering the overriding objective. And I simply say that Your Honour has the powers on that basis.
Right. Okay.
And that those include the necessary extension of time for the purposes of filing an acknowledgement of service in order to challenge the court's jurisdiction, which, as Your Honour will be aware, is either to say that it lacks jurisdiction or to say that it should not exercise the jurisdiction which it does have I would say that that is likely the latter. We have to file a form for acknowledgement of service. This has been sought to be done, ticking the box that says that jurisdiction is to be contested. We need time to be extended retrospectively to bless our having filed that yesterday. Similarly, we have sought an abridgment of time so that this application is before Your Honour fully inter partes.
Yeah. Can I just, on those relatively mechanical sides, first of all ask, obviously the application was served on the claimant. Can you tell me when that happened?
Yes, one of my colleagues will give the time, but it was served by email yesterday afternoon.
Right.
I'm not sure of an exact time, but it was served on Mr. Montague Smith because we saw that he'd been involved, as well as, of course, his instructing solicitors, DLA Piper.
Well, now the second mechanical thing, I have the impression, I may be wrong, but in fact a form of acknowledgement of service has now been filed, and what you are really seeking is a retrospective validation of that by an extension of time. Am I correct? And if so, when was it filed?
Exactly so, Your Honour. It was filed yesterday afternoon.
Right. Okay. Thank you.
Well,
If we get to Mr. Montague Smith, I'll see whether there is any difficulty in either of those two aspects.
Yeah, thank you. In terms of the nature of the relief sought, Your Honour will have seen, if you've read, having read the witness statement, that my clients have entered into a non-disclosure agreement with Select Group, who are a well-established and substantial property developer here, who I believe are well known.
I have looked at that agreement through the link.
Thank you, Your Honour. And what that does is it's obviously obligation to preserve confidentiality on the part of Select. It gives them a period of 3 months exclusivity, followed by a further 3 months in which they have a right to match any other offer obtained by my clients. It has also been crafted so as not to prejudice my clients' ability to deal with secured lenders or indeed to prejudice that security. So whilst not in any sense conceding that any power of sale is one that could be sought by way of self-help, which as I understand is the claimant's position, is that it is deliberately designed to not to prejudice the position beyond the other thing, and the undertaking which is scheduled to the order would be an undertaking by my clients to the court to cooperate, to register an extension of the present mortgage, which runs out on 30th of June. And the purpose of that is to ensure that there is no lapse in the security rights and that any misadventure by other security rights that either the DIFC investments may have with respect to its fines or otherwise would be prejudiced. Your Honour, we noted that it had been the position that Mr. Montague Smith had, as clients, had offered alternatives to Your Honour, which included an extension of the mortgage, I think until December of 2021. We are simply seeking an extension that is 1 month longer than the period of first exclusivity and then topping rights or right of first refusal of the Select Group. We made it 1 month more simply so that there was not to leave some latitude. So far as if of course the claimant wishes to extend it for a longer period, I would have instructions to give that undertaking with respect to the longer period originally sought by Emirates MBD, if that arises. I mean, Your Honour, I note from Your Honour's judgment that you had expressed and was discussion about the equity of redemption, which ordinarily disappears as a result of foreclosure. One significant issue which may arise is whether, as it is the case, that therefore extinguishes any guarantee liability on the basis that the corporate and personal guarantees are to secure the debt and that the debt would have disappeared, or whether Emirates MBD will be seeking a distressed sale in a deeply distressed market, and whether they would then be faced with guarantee liability as well. In terms of assuming that Your Honour is with me that you have these powers, then the immediate question is this sort of balance of harm and convenience, with respect to which we say that potentially enormous damages for my clients in having had forfeit this very substantial plot, which I mean, Your Honour will be familiar with the DIFC. This is a large plot immediately opposite the new Brookfield Tower that has gone up between the Waldorf Astoria Hotel and Sky Gardens. It's right in the centre of the DIFC. I'm sure it's in the overwhelming interests of the DIFC, of Emirates MBD, and of my client that this plot is developed, if it can be, and for it to be sold in a full sale, perhaps by public auction at this moment, would be could have consequences for my clients which are very difficult to quantify, knock-on effects on all of the other lenders under the restructuring. And as it was in the evidence before Your Honour, that the Al Jaber Group, although evidently in significant distress, remains a very substantial employer in the Emirates, and it has, there are a large number of employees whose jobs depend upon its health in what, as Your Honour knows, is a very difficult time, and for a forced sale to happen in the present market would cause a great deal of avoidable damage and distress. My clients seek a realistic chance to be able to pay off this debt and keep their property. And unless I can assist Your Honour any further, those are my submissions.
Yes, thank you, Mr. Turner. Mr. Montague Smith.
Thank you, Your Honour. I'll try and be brief. My learned friend's obviously in a very difficult position, and his application is, to say the least, problematic, because we've had a trial, the issues have been resolved, and I think he frankly accepts, or at least he makes little attempts to escape the consequences that flow from that. And so you've seen from his skeleton argument, he broadly makes his submissions as if his client's application for the adjournment had succeeded, and this was the adjourned trial. But of course the adjournment was refused, and there's no challenge to that, nor could there be. So what I say is that this is a final order, so there's no power to amend this final order at all. And I'll look at the case management powers briefly. But even if there is a power under those court rules which deal with case management, then the court should not, as a matter of law, exercise any powers that it has under those rules, because that would be to relitigate matters which could have been or would or were resolved, and to deal with arguments that could have been raised on the 4th of June. And the authorities are clear that it doesn't matter where the power to amend comes from, even if it's a completely interlocutory order, then the court should not revisit that, if to do so would in effect be relitigating the issues that have already been decided, or dealing with the arguments that, even if they weren't raised, could have been raised at the previous hearing. But I say that there's just no power, because if you actually look at the order that my learned friend has to seek, it doesn't work. You don't get there with the case management powers he relies on. So just going through them very briefly, Rule 4.21 gives the court power to extend or shorten time for compliance with any rule, practice, direction or court order. So that's about complying, the time that my learned friend's clients have to comply with the court order. And of course, what if I don't know if Your Honour has the draft in front of you. It's probably the easiest way to look at this.
I have it in front of me, yes.
I'm grateful. So if you look at paragraph 3 of that's where he seeks to vary the order that's been made. And so what he wants to do is vary paragraph 1, or order 1 that Your Honour made previously, which says, on or before the 23rd of June, the defendant shall stand absolutely debarred and foreclosed. And so that doesn't impose an obligation at all to comply with any order. So there's no time limits to be extended by reference to Rule 4.21. And same for Order 2. The 3 is dealing with costs. Now, I suppose, although he doesn't really make this argument, what one might say, well, Order 4 is the closest to the sort of order which one might expect to see affected by Rule 4.21. I say it's not actually that sort of order, because actually if you look at it, it gives liberty to apply in the event that certain obligations are met by the 23rd of June. But those obligations are not obligations that are imposed by the order. Those are obligations that are imposed by the commercial contractual relationship between the parties. The claimant selling the property is obviously irrelevant at this point, but what my learned friend would need to do to get this order within 4.21 would be to say, well, 4A, as he's recited it there in his draft, imposes an obligation which needs to do a certain act by a time, which needs to be extended by Your Honour. But that doesn't work at all, because the obligation that is simply recorded by the order is an obligation imposed by the contract, not by the order. It simply says if certain conditions arise, then there will be liberty to apply. It's a conditional liberty to apply. It doesn't even say liberty to apply by a certain date, albeit that's implicit. So actually, Order 4 doesn't fit within Rule 4.21 at all. And even if it did, it wouldn't get my learned friend where he needs to go, because he's still stuck with Orders 1 and 2, which provide for foreclosure on the 23rd of June. So if there was then to be some sort of subsequent application permitted to apply to set aside those orders, then by that stage the property would already be vested in the claimant, and so my learned friend would need to go further. He would need further orders from the court to unwind Orders 1 and 2. So there's just no way to get there on this order without attacking Orders 1 and 2. Is my short point on this, and you can't do that using any of the case management rules which my learned friend relies on. And 4.26 was the second rule that was relied on. That simply permits the court to stay the whole or part of any proceedings or judgment, either generally or on a specified date, and there's no application before the court for a stay, as my learned friend made clear. So that's just irrelevant to the questions that Your Honour's faced with today. And if there was an application for a stay, it would be resisted. But I don't need to tell you about that, because there is no application of that sort. And then 4.214 is a sort of Hail Mary, which is relied on to say the court can, quote, take any other step or make any other order for the purpose of managing the case and furthering the overriding objective. So there's a broad case management power, but we say that the case has ended. That's the whole point. Your Honour's made a judgment, made an order after a trial. That's it. And so, it's clear from the authorities that you can't rely on general case management powers to unwind previous orders that have been made. Where those issues have generally arisen is not where there's been a final order, but where there's been an interlocutory order, and the courts have been very clear in those cases, you can't just rely on those general case management powers to keep coming back and try to vary interlocutory orders. And those judgments are all in the context of interlocutory orders, because I don't think anyone has been bold enough to come back to court and say, well, we've had a trial, you've made your decision, but you've got a general case management trial power to make a different decision. And I think it's really for that reason that my own friend's submissions on this were extremely brief, because he knows that quite frankly, Your Honour's hands are tied, even if Your Honour thought there was a good basis for interfering with the order that you've made, which for the reasons that I've tried to explain in my note, I say there aren't. So the point is that there's just no power here. You can't go back and vary an order. There's no jurisdiction. You can't go back and vary a final order that you've made. You certainly can't use those case management powers to do so. But even if you could, even if those case management powers permitted it, or even if there was a liberty to apply generally in the order, which there isn't, the further point is this one that arises on those cases about interlocutory orders. You can't just keep coming back and making new points. If the points that you raised were all available before at the previous hearing, then that's it. You're again, the court is constrained in what it can do. And I've referred to a few authorities on this. I don't know whether I need really to take Your Honour to them. But does Your Honour have my authorities? I think that I've got them in a zip, but I don't know whether you've got any of them before you.
I have a zip file which has only the arbitration law in it.
A zip file with only oh, you don't have any authorities from me then. I think that they were uploaded last night, and I'm afraid it may be that they've only been partially downloaded for you. I'm afraid I've got quite a few. I've got 12 just to be sure, but
I don't have them.
Right. Well, I apologise for that. As you know, I mean, I received this about 10:30 a.m. yesterday, my time, and I was otherwise engaged for about an hour, and so we had to scramble to get a note together for you and get the authorities over to you. So I apologise that the authorities haven't quite made it to you, but it may be that I don't need to take you to them, or well, if I can't, then that's probably the best situation. But bear with me 1 second. I'm just getting a note from a solicitor. Yeah, they were uploaded last night. Are they definitely not on Your Honour's e-link?
No, I was sent by the registry. I'll just go back to it to make sure I'm right. I have just received some supplementary authorities, which I think are from Mr. Taylor's side.
Yes.
On SharePoint, etc. I have I've been sent a link which I opened, which is a zip file. Hang on a minute. I may have wrong. In fact, I have got it wrong. My apologies. I did not tap far enough. I the authorities.
Super. In which case, what I can do is just very brief. All I want to do is show you some very brief passages from some of those authorities, if I may. The first I want to show you was the Lloyd's investment case, which you'll find at tab 4.
Yes, I have that.
And if you go, please, to page, it's the second last page of the PDF, and it's the second half of paragraph 15, so the large paragraph just before 16.
Yes, I have that.
And if you'll see there that the judge is saying, it seems to me, therefore, that although Mr. Justice Lloyd had no formal application before him to set aside Mr. Berry's order, he in effect heard the very same argument which I have heard on this application today. He rejected any suggestion that there could be a successful attempt to set aside Mr. Berry's order on those grounds, because this is a case where the Deputy Judge's failure to consider the effect of the freezing order and the defendant's asset position was simply the result of the defendant's failure to communicate those facts to his representatives and their failure to raise them as issues which they considered relevant to the exercise of the judge's discretion. In these circumstances, this seems to me, as it did to Mr. Justice Lloyd, a case where the defendant is really seeking to re-argue the application that was before Mr. Berry on grounds which were available to him then, but on which he chose not to rely. And that is not a course which, in my judgment, is open for this court to take. The only possible course open to the defendant is to seek to appeal Mr. Berry's order out of time and to apply to admit new evidence in the form of the material about the freezing orders. So that's an interlocutory scenario where there is clearly a court power to go back and vary the order, but the court is saying at the return date, on an inter partes basis, there was an opportunity to make the points that are now being made, and I'm just not going to hear them because I can't. Why not? Because you can't just have the situation where you keep relitigating issues over and over again. We can see the only DIFC authority that needs to be referred to on this is authority tab 7, which you'll find, which is a case called Vanin, which came before His Excellency Justice Ali Al-Madani, and there's a very short passage on the 10th page of that.
1 minute. Yes, I'm on page 10.
Thank you. So you'll see it, the second paragraph down. The rule in Henderson and Henderson applies so that a party cannot make repeated or successive applications where the grounds relied upon in the later applications existed or were available at the time of the first application, and still less when those grounds were relied on but were rejected by the court. And then you can see the court relying on the English position in the Lloyd's investment case. That's the next paragraph, and also refers to the case of Chanel and Woolworth at paragraph 39. Even in interlocutory matters, a party cannot fight over again a battle which has already been fought unless there's been some significant change of circumstances or the parties become aware of facts which he could not reasonably have known or found out in time for the first encounter. One cannot imagine that parties may be allowed to continue fighting over the same issues surrounding an order without end. The judicial orders must provide stability and some sort of finality to the issues between the parties, even if the issue is not on the merits of the case, and deciding otherwise could lead to endless appeals on the varying of orders, where the losing party would drag the application before a court for long periods that would defeat the court's objectives to deal with cases justly, fairly, and in a reasonable period of time. So that's clear. Even so, as I say, I don't accept that that these powers that my friend relies on allow Your Honour to revisit this order at all. But even if they could, he needs to show some material change in circumstances or some facts which he wasn't aware of, and he can't do that. The best he can do is say, well, the defendant has finally got around to trying to negotiate the sale of this property, but that's not a development that's out of his client's hands, and that is not something which is new in the sense that his client could have taken that position and was always in a position to take that position at the last hearing. I've heard today that there's some suggestion, although I don't think it's suggested positively, but there's some suggestion that perhaps Ms. Fatima Al-Jabir, who appeared last time, was not authorised to represent Al-RIHAB, and therefore there might be some point about whether or not Al-RIHAB was in fact present at the last hearing. And that would, there are provisions in the rules which deal with the circumstance where a party fails to attend a trial, and in those circumstances there is a special regime for reopening orders that were made, and that's under Rule 35(16). And I've set that out in my skeleton. We don't necessarily need to go to it, but there is a series of...
Your skeleton does refer to it, but at the moment I don't see that there's anything in the defendant's application that invokes that rule.
No, quite. So, but my point about identifying that is that cements the position that there are very limited and narrow circumstances in which the court will go back and look at an order that it's already made, particularly after a trial. That there is the rules set out very narrow circumstances in which that is available. The specific trumps the general, and so you can't go back and rely on general rules to try to get around and circumvent the very narrow regime which the court provides. Otherwise, you make the narrow regime completely otiose. So I say this is a final order. Even if it wasn't, the opportunity to make the points against the order on the 4th of June was available, and could have been those points could have been made previously, and at the very least they could have been made sooner than they are now. You want to mention the timing of the application, and we do object to the application being made on short notice. Your Honour may say, well, it's all before me now anyway, but this won't be the end of it. If Your Honour was to accede to this application, we would have an opportunity to apply to set it all aside, because this is effectively an ex parte application. Because of the timing, it's on short notice. It ought to be treated as an ex parte application on the authorities. And again, I've provided reference to the relevant English authorities, at least on that.
Nonetheless, whether or not that might be a consequence, I don't think is something that I need to rule on.
No.
I think I probably should abridge the time for service on the basis that you have quite properly come forward and responded as to it, including making a point that it should be regarded as an ex parte application. So as a matter of form, it strikes me that I should bridge the time for service to allow to retrospectively validate, as it were, the service yesterday afternoon.
Yes.
Is there any particular problem with it?
No, I can see that. I can see the sense in that.
While we're on those sorts of matters, I feel also I probably should bridge the time for filing an acknowledgement of service, because that is effectively a way of getting King and Wood Mallison on the record. Is there anything you want to say about that?
Well, I think that is problematic, because the case is complete. Now, if Your Honour saying, well, I'll permit that document to be filed and therefore for King and Wood Mallisons to come on the record, then I can understand that. But if it goes further than that and is somehow construed as permitting the defendants to state the position formally that they resist this order or these proceedings on the basis of jurisdiction, then that is problematic given the stage of proceedings to date. And also given the practicalities of the situation, which is that the mortgage expires in 8 days. So I think that is more difficult. I don't have a problem with the position that King and Wood Mallisons are on the record, but I think I do have a problem with an extension of time to file an acknowledgement of service, because it muddies the water as to whether or not what has gone before is somehow superseded by that extension.
Yes, I understand. We'll get back to Mr. Taylor about that in a moment. The alternative is that the rule which says that the party does not file an acknowledgement of service, they can only appear with the permission of the court, might be the one that is now operating.
Yes, precisely. So I don't go so far as to say Your Honour shouldn't listen to anything that Mr. Taylor has to say today, and you know, it just, I think Your Honour can take those submissions on board. So I wouldn't oppose an application for permission to be heard, notwithstanding the lack of an acknowledgement of service. So Your Honour, those are sort of what I'd done was just explain to you why I say this application doesn't get off the ground at all, in terms of the powers that there are. But so what I say is that even if the defendant was correct in its complaints about the way in which the case went forward, there's simply no jurisdiction to revisit the order. And even if there was jurisdiction, you shouldn't do so, because we're relitigating issues. So the defendant needs to go to the Court of Appeal. But in any event, the core complaint which is made is simply wrong. Well, what is said is that the claim should have been the subject of arbitration, not of court proceedings. And I say that there are any number of things that are wrong with that argument. And the most obvious response to that point is that there is no obligation on the court to stay proceedings in favour of arbitration, even when there is an arbitration agreement, unless a party requests that the court do so. So the language in the law is slightly different, very slightly different from the New York Convention, but it amounts to the same thing. And you've got the law at tab 1, I think, of my authorities. And we can see Article 13 is on page 5 of that. Sorry, does Your Honour have that? Hello?
We appear to have lost His Honour.
Ah.
Are we back online?
Yes, we are. I think we're all here. Thank you.
Very good. It's still up just as we finished on the question of an acknowledgement of service.
I see. Thank you. Yes. I think unless you wanted me to address you any further on the acknowledgement of service, I was simply going to, all I did was summarise my position in relation to the court's power, that there isn't any, but even if there is, it's re-litigation, and so it has to go to the Court of Appeal. And then I was going to move on and make the point that the core complaint that my own friend makes, that this ought to have been brought by way of an arbitration, is also simply wrong. And I was saying it was wrong for really a whole host of different reasons. But the most obvious point, the most obvious reason why it's wrong, is because this court has no obligation, like most model law jurisdictions, this court has no obligation to stay proceedings unless a party asks the court to do that. So there needs to be an application requesting a referral to arbitration before there's any obligation to enter a stay. And I was saying that while the language of the law in the New York Convention is very slightly different, it amounts to the same thing. So I was going to take you on very briefly to the arbitration law itself, which is tab 1 of my authorities.
Yes, I have looked at that also.
I'm grateful. And I don't know whether Your Honour's seen the commentary from Vandenberg on this point, which is my tab 12. Which does a useful job in that it goes through the travaux preparatoires of the particular provision and makes the point that there was a specific vote on this issue when they were drafting the New York Convention. And so if Your Honour has tab 12 and goes to page 138 of that.
Just 1 second.
Certainly.
Yes, page 128. Yes,
138 it is.
38. Beg your pardon.
No, my fault. So the point that's being discussed here is that the United Kingdom had introduced a proposal that the court be entitled to refer to arbitration of their own motion or at the request of one of the parties, and then we see at 138 where on the second line the commentary continues, a surprising about-face occurred on the part of the delegates, and the Israeli proposal to delete the words of its own motion or was adopted unanimously, so to remove that provision for the court to refer of its own motion. And it says, this brief historical account of the words at the request of one of the parties shows the final prevailing view of the drafters of the convention that a court can refer to arbitration only if one of the parties so requests. If a court is faced with a contract containing an arbitral clause falling under the New York Convention, but none of the parties objects to the competence of the court on the basis of that clause, the court may not refer the parties to arbitration on its own motion. And it says here again we encounter an internationally uniform rule which supersedes domestic law. Consequently, the rule to be found in some laws that a court may refer the parties to arbitration on its own motion is inapplicable where the arbitration agreement falls under the New York Convention. Furthermore, the history makes it clear that if a party does not invoke the arbitration agreement, the court will retain competence to hear the case. It also implies that the non-invocation by a party of the arbitration agreement must be considered as a waiver of the right to go to arbitration. And this is the other side of the coin. Having the freedom to agree to arbitration, the parties must also have the freedom to renounce explicitly or tacitly the agreement to arbitrate. So the point was specifically voted on for the New York Convention. That's what the model law is based on. That's what the DIFC arbitration law is based on. And so this position that's taken by my learned friend that somehow an arbitration agreement deprives this court of jurisdiction is simply wrong. An arbitration agreement doesn't change the question of whether or not this court has jurisdiction. It simply gives rise to the right of one party, if it covers the dispute, to say that dispute must go to arbitration, therefore these proceedings must stop. But what it doesn't do is impose any obligation on the court either to stay when nobody is asking for a stay, or alternatively to unwind any judgment that the court does make. And there are deadlines for making these sorts of objections and asking for the stay. And in the arbitration law in the DIFC, it is the time when the first defence is filed. And there might have been an argument about whether or not, therefore, time expired when the defence was due. And I think my learned friend's taking the position, well, actually, it's about, in effect, he says, well, you can just not file your defence, and then you could turn up at the hearing and say, well, actually, now I want my stay. So there might have been an argument about that, but it seems to be what's quite clear is what you can't do is just allow the case to run to judgment and then come back afterwards when it goes against you and say, oh, actually, no, I want all of this resolved in a different forum. I want to take this away from this court, even though the court's decided it, and bring it back into an arbitration. So, and that's effectively what my FO is trying to do. He doesn't like the judgment that came out, so he wants to go back and say, well, actually, that should have all been done in arbitration. Well, it's too late for that, and there's no mechanism, unsurprisingly, for the court to go back on the basis of the New York Convention or the model law provisions and simply set aside an order which it has made. I point out in my skeleton argument, you do see judgments in respect of disputes as a result of this, which are clearly covered by arbitration agreements. And the most frequent circumstance in which this arises is where a party seeks an anti-suit injunction in support of an arbitration agreement. Because if you make a claim for a final injunction, rather than just an order and an interim injunction for an anti-suit in those circumstances, then you are seeking something which is really subject to the jurisdiction of the arbitrators. It comes within the terms of the clause. And the problem arises normally because in those circumstances, the defendant's not normally in a position to say, I want to stay in favour of arbitration, because normally they're the ones breaching the arbitration agreement, so they're making the argument that it doesn't apply or isn't binding or whatever. And I mentioned the case of Norrie Holdings in my skeleton argument, which is an example of that situation where the courts in England have said this precise problem arises, and if nobody says, I'm going to make in that jurisdiction a Section 9 application, Section 9 of the Arbitration Act, which is equivalent to the provisions here. Then if they don't make that, then there's no reason why the court shouldn't go on and exercise its jurisdiction to grant the anti-suit relief that's been sought. And those authorities were applied in a case called Hayrie and Hazim in these courts. I'm afraid the judgment that we have, which is at tab 8, doesn't illuminate the situation very much because it's a very short ruling that was made. But it is clear that what Justice Jeremy Cook was doing in that case was he was granting final anti-suit relief in circumstances where undoubtedly there was an arbitration agreement which would have covered that final relief. And so you have precisely the same approach here as you have in England. And so there's no basis to go back. The court can make orders even where the claim that is being made is subject to arbitration agreement. The court can make final orders in those claims, and they can't be set aside unless the defendant has in time made its application for a stay. You can't, as my friend would have it, wait and see the outcome and then apply to set it aside. So there is no arguable breach of the law. There's no arguable breach of the New York Convention. Just on this basis alone, there's no arguable basis to say that you're on a lax jurisdiction, even if that point could be raised before Your Honour, which I say it can't. And that's even before you get to the question of whether or not the arbitration agreement actually applies to this claim. We say it just doesn't. And what my learned friend does is he takes a single clause from a highly complex set of restructuring documents and says that that applies to this claim. And we say it doesn't, because the right to enforce security is carved out at every stage. And the common terms agreement that my learned friend relies on doesn't purport to deal with security at all. And that you may recall that there were lots of other agreements in that, including the intercreditor deed and the priority deed, between different parties which regulated different aspects of the security. But the mortgage agreement itself does not contain an arbitration agreement, as Your Honour has seen. And the other point is that the amendment agreement, which Your Honour records in the judgment, the amendment agreement which comes after all of the restructuring agreements and so would supersede it if there was an arbitration agreement covering this dispute. That mortgage agreement says that the claimant can take, quotes, legal actions to recover the debt in full, without restriction on what those legal actions would be. So we say, well, as a matter of construction, and I don't think we really need to go into the granular detail of this, but as a matter of construction, this is not a claim that was covered by arbitration. But I also say that that is not surprising, because an enforcement action of this sort is not the sort of thing which could be the subject of arbitration, because it's about the status of property. Your Honour will be aware, I think, of the English cases about where the dividing line comes between what is and what is not arbitrable. And the Fulham Football Club case in the Court of Appeal in England was sort of the last word on that, until the Court of Appeal more recently in Bridge House confirmed the approach in that. But it's worth just pointing, Your Honour, to two very short passages of the Bridge House case, which is, as I say, the latest word really on where this dividing line arises. You have it at tab 11 of my authorities.
Yes, I have that. Whereabouts?
If we go to paragraph 58, which is on page, I think, 17 of the transcript.
Yes, I have that.
Thank you. So here, I think it's Lord Justice Newey is referring to the Fulham Football Club case, and he says, it remains the case, as Lord Justice Patton noted in Fulham, that many aspects of the statutory regime governing companies are immune from interference by the members of the company, whether by contract or otherwise. Lord Justice Patton observed that a winding up order lies within the exclusive jurisdiction of the court. There can be no question either of an application for restoration to the register under section 1029 of the 2006 Act being susceptible to arbitration. And this is the point, this is the key reason why not. Such matters do not merely involve private disputes, but status, and potentially have implications far beyond the company and any particular counterparty. So in effect, what he's saying there is that the dividing line falls between, on the one hand, in rem remedies, and on the other hand, inter partes disputes. And so to that end, it is relevant that the defendant doesn't here raise any dispute as to whether, for example, the debt which is claimed was due. Now, if that was raised, then it's possible that that might be a dispute which should be referred to arbitration. So there might have had to be a stay pending determination of that issue at arbitration. One can see that theoretically. And we also see it if we go down to Lord Justice Males's judgment in that case, just very briefly, scrolling down to the final page, paragraph 79. On the third line, Lord Justice Males says, while I would accept that there are some kinds of application which are incapable of being arbitrated, of which an application to wind up a company is an example, this should, in my judgment, be a conclusion of last resort. Even then, it may be appropriate, as illustrated by Salford Estates, for particular issues falling within the scope of an arbitration clause to be referred to arbitration before the court decides whether to make an order which only the court may make. So my learned friend says you don't generally need a dispute for a commercial dispute to be subject to arbitration, to be referred off to arbitration. But in the context of an application for relief which only the court can make, and foreclosure must, I say, fall within that, because it's about status of property. In that context, if you don't raise a dispute which could fall within the provisions of an arbitration agreement, then there is no obligation to refer. And the points raised on this application are purely about the in rem relief granted by the court. So on my own friend's own draft order, he's saying, well, on or about, he's effectively looking to amend the terms on which foreclosure was granted. He's not saying that there's any dispute about whether or not foreclosure should be granted at all, or whether or not now he doesn't concede that, but he doesn't raise any particular issue. It's never been said that and it couldn't be said, it seems to me, that the debt isn't due. So on that basis, there would have been nothing to refer to arbitration, even if a timely request had been made. But it also goes to the question of whether or not this claim is properly to be construed as being within the terms of the arbitration agreement. So the fundamental argument that's raised of arbitration just doesn't get off the ground for a host of different reasons. We now have a new point that's raised by my learned friend on the telephone this morning, which relates to the Dubai mortgage law. It's not developed in the skeleton argument, and I'm not completely sure that I understood it, but there is an attempt to import via the Dubai mortgage law the provisions of Article 249 of the Civil Code, which are similar, I think. They're in effect sort of force majeure provisions, which are imported into contracts and arise in cases of what he described as hardship. I haven't looked at the provisions of the Civil Code in that regard, but assume that he's right about that. That just simply, all it does is it just raises issues, firstly about the meaning of the mortgage agreement when it refers to the Dubai mortgage law, and we would say that the reference to the Dubai as opposed to the DIFC law on this was clearly just an erroneous reference. But even if that was wrong, and you do just import some sort of force majeure provisions, you would have to show that as a matter of fact, the conditions for adjusting the contractual agreement have arisen, such as to exclude my client's right to apply for foreclosure. So in other words, he'd have to establish the hardship that he relies on, and that it was unreasonable to permit my client to enforce. And that, I'm afraid, is just hopeless. Not just because if one steps back, that's just a very extreme submission to make. My client's simply not entitled to enforce its debts because, well, for unnamed reasons of hardship, but there's no evidence to support it whatsoever, even now, still less at the hearing before. So there's just nothing in the points, the substantive points that are being raised, and so even if these points were brought to Your Honour's attention on the 4th of June, they wouldn't get my learned friend anywhere. And really what we're back to is just relitigating the issues from the 4th of June. So the defendant's asking for more time. It just wants more time. And the court was unimpressed with those arguments on the 4th of June, and I say it should be unimpressed with them now. Not least because the defendants had now a further opportunity to explain the delay, and we've got just total silence on that issue. We don't know why the debt wasn't paid. We don't know why there was no response to the claim. We don't know why the defendant didn't try to sell this property much sooner. We can guess and we can infer why the defendant did not make its application immediately after being refused an adjournment, but instead waited to see what happened on the hearing to decide whether it liked the judgment that Your Honour made before attempting to set it aside or vary it. But that, I'm afraid, explanation which we can infer does not improve its position. To the contrary, it makes its position much worse. But we don't know why it then waited to instruct lawyers after that decision came out until the Thursday, the 18th of June, apparently, albeit it sounds like that was when the onboarding process was complete with Kingwood and Mallisons. So what we're asked to do now is trust that, having failed to comply with the contract, the defendant's now going to honour an undertaking that's proposed will be given. The undertaking is that the defendant undertakes to cooperate with the claimant to enter into an agreement to amend the terms of the mortgage and register that amendment. And quite frankly, one can see why the offer is being made, but in short, I'm afraid the claimant just doesn't really trust the defendant anymore. And to be honest, it's hard to blame them. We were told previously...
Mr. Smith, I'm sorry to interrupt. Are you able to tell me on instructions whether or not there has been an approach by the defendant with a view to extending the duration of the mortgage other than through this application?
Other than through this application, in the context of this application, I do not. I think not.
Were they knocking on the bank's door last Wednesday or Thursday with an extension in their hand?
No. I'll wait for confirmation of that. I've got instructions coming, but I've never heard of that, and no, it's clear. No, that hasn't happened.
Right.
So what we have is an application made yesterday, and then there was some attempt to approach on that basis. But as I say, the short answer to all of that is that the claimant doesn't really doesn't trust the defendant as far as they can throw him at this point. Assurances were made previously that steps would be taken to rectify matters, not by extension. But Your Honour may recall there was some evidence to the effect of discussions that happened and promises that were made, but that just resulted in time being wasted in the past. And the other point I'd make, and Your Honour recorded it in your judgment, was that we were told at the last hearing that a month was needed to get lawyers on board. And then when Your Honour indicated that a week might be available, the response was, well, that might be enough. Now, of course, the question of whether or not lawyers, more time, how much more time is needed, is a matter of opinion. But when it was said, we need a week, there is a factual question. Sorry, we need a month. There is a factual question about whether or not the defendant and the people who made those statements genuinely believed, when they said those things, that they needed a month. And quite frankly, when their immediate response is, well, actually a week might be okay, one has to say, well, the implication of that is that when that statement, that assertion was made, that we need a month, there was no genuine belief that that was in fact the case. And we were also told, I point this out in my skeleton, that the defendant needed access to external lawyers. And then it turns out that they have Mr. Murphy available, who is a dedicated, apparently, legal advisor within the company. And so the implication, again, of the submission was that they were bereft of legal input. Now, no, at the very least, one would have expected some sort of frank explanation of what legal resources were available, but we didn't have that either. Now, the proposal now is that there's going to be an undertaking to take rather unspecified, rather vague steps to extend the mortgage pursuant to an agreement which hasn't even been proposed. And quite frankly, we doubt whether or not that will be complied with once that undertaking is given, if Your Honour was to extend the order or make any of the amendments that are given. So those are really the sort of commercial reasons why my clients are not willing to go down this route, not willing to simply to consent to all of this. It's not, I say, in Your Honour's hands to permit this anyway, but I'm just trying to give Your Honour a sense of where my client is coming from on all of this, because if the undertaking is given and then for whatever reason the agreement isn't entered into or it isn't registered, and that will to some extent be in the defendant's hands, then my client has no comeback other than an application to commit, at the moment, unspecified people for contempt. We don't even know who the officers of the company are. Everybody you've heard from in terms of evidence and submission is either, apart from Mr. Taylor, appears to be associated with the parent, not actually with the defendant. But more generally, the defendant just considers that there really has just been enough delay from the defendant. Enough was enough at the last hearing. Your Honour felt that the adjournment application then was a spoiling application. We have the same concerns about this one. And we also have concerns about really how this would work in practice, because if we could agree, and say we could agree an extension and get it registered in time, we have concerns about whether that would truly protect the claimant's position. So, for example, if there are other parties who are owed money by RIHAB now, they might have something to say about an extension of the existing security, which would otherwise expire at the end of this month. We don't know, I say we, the claimant does not know whether RIHAB has other debts and therefore other creditors who might have an interest in spoiling any further extension, but Your Honour saw how many group entities were used to guarantee the group's debts at the first hearing, and we simply don't know anything about the defendant's position, what asset, whether it has any other assets. We don't understand that it does, but more importantly, whether it has any other creditors who might be lining up. Nor, and I make this point, nor, frankly, is there any evidence of prejudice at all resulting from the order. It's far from clear that the defendant will actually be prejudiced, because the effect of foreclosure is cancellation of the loan. And so the question of prejudice, which my own friend leans on quite heavily, it depends entirely on the value of the land, number one, and secondly on the outstanding debt to DIFC Investments, which is provided for in the previous order. And so it's only if the value of the land exceeds all of the debt which is secured against the land that this would cause the defendant any problems at all. And the defendant's provided absolutely no evidence on any of that. So I say at every stage this application is flawed. There's simply no jurisdiction to amend an order which has already been made, or Your Honour can't, however you want to put it, Your Honour can't revisit it because it could have been re-argued previously. The core complaints about arbitration and this other one about the Dubai mortgage law, they just don't work. But even if there was scope to do something about this, it would not be right, we say, to grant the extension anyway. So unless Your Honour has any questions, those are my submissions.
Thank you, Mr. Montague-Smith. Mr. Taylor, what would you like to say in reply?
Yes, I'll briefly in reply. The first point is this: on change of circumstances, is that there's the one thing that could not have been relied upon was the agreement with Select, the non-disclosure agreement at the auction. That was executed, I think, yesterday. So that would be a new feature. In relation to the duty of the court to stay, I have no argument with the proposition that there is no mandatory obligation to stay unless a request is made. The reason in my respectful submission that the DIFC arbitration law, that section 13, uses the expression that the request to stay should be made not later than when submitting his first statement on the substance of the dispute, is put in elastic terms like that, because the first statement on the substance of the dispute will depend whether what is at issue is a Part 7 application or a Part 8 application. Because amongst the differences, I mean, with the Part 8 application, there are not ordinarily pleadings, there is no defence, there can't be judgment in default of defence. So the provisions, and if it should probably take Your Honour to Part 8 of the rules.
Yeah.
Is, if one sees at 8.13, there is the requirement of the defendant to file an acknowledgement of service not more than 14 days after service of the claim form. I don't think anything turns on it as far as we can tell as to when service was effected, but since service would have been in Abu Dhabi, I believe that 14 days is extended to 28 days under the rules. The requirements, as Your Honour has made reference to 8.16, which provides that a sanction of failure to acknowledge service if the time has expired is that attendants may only be take part in the hearing that requires permission. Now, I don't know whether that permission was given to Ms. Jabba when the hearing before Your Honour. The other point I should draw your attention to is that 8.26 is that a defendant who wishes to rely on evidence must file it when he files his acknowledgement of service. Now, in my respectful submission, Your Honour, if there was going to be a first statement on the merits of the case, that is when that would arise. If, on the other hand, what is intended is a challenge to jurisdiction, then that engages Part 12, Your Honour, so that a defendant in 12.1 who wishes to dispute the court's jurisdiction to try the claim or argue that the court should not exercise its jurisdiction. And where there is a reference to arbitration, I would say, Your Honour, that is it. It's not that the court necessarily lacks jurisdiction, but that it has been displaced if the arbitration agreement is invoked. How must that be done? 12.2, a defendant who wishes to make such an application must first file an acknowledgement of service in accordance with Part 11. Now, Your Honour, one way in which this was put in the witness statement, which I didn't take Your Honour to in terms of the court's case management powers, is the court's jurisdiction to relieve from sanctions, which is in 449. That provides that on an application for relief from any sanction imposed for a failure to comply with any rule, practice, direction, or court order, the court will consider all the circumstances, and it talks about the interests of administration of justice, whether an application has been made promptly, whether the failure to comply was intentional, etc. Now, by and large, what this is addressing is sanctions that have already arisen from which relief is sought. If it's a cost order, then the only means of appealing is by way, the only means of redress under 447 is to appeal against the order for costs. But in my respectful submission, Your Honour, what happened here, and bearing in mind in terms of the overriding objective, is that whatever other status Miss Al-Jaber had, she certainly wasn't a Part 2 authorised representative, and that it's incumbent upon the court, in my respectful submission, even though it is a corporate defendant, to have treated it in the manner of a defendant that was not professionally represented. And what was sought and refused was time. Now, that time should and could be extended to time to file an acknowledgement of service. And Your Honour, although I'm afraid I don't have authorities on this, is that when the acknowledgement of service system was introduced to replace the former appearance and conditional appearance, in the early cases, one question was whether an application by a defendant to extend time be treated as a step in the action. And the cases said, no, it's got to be an absolutely categorical submission to jurisdiction. So the sanction, which I would say the court is able to relieve, is in the form of the extension which has been sought for the filing of the acknowledgement of service. And
I'm sorry, Mr. Taylor, I'm sorry, you've quite lost me. What's the point of this? You're apparently putting up some sanction and saying that can be relieved from. Now let's start. What's the sanction?
So the sanction is the inability to challenge the jurisdiction of this court, which is not one that can be confirmed.
That is not a sanction which has been imposed by the court and which can then be relieved on. That is completely out of the question. Please move on.
Well, it's imposed by the rules, Your Honour.
It is not a sanction imposed by the court, rules or otherwise. Move on.
All right. If you're not satisfied on that, I will move on, Your Honour. In relation to no dispute to go to arbitration, again, I don't disagree with where the dividing line, as described in cases by Mr. Montague Smith, comes between matters that can only be affected by the court, such as foreclosure, changes to the register, or the winding up of the company. But as he said, the question of the dispute that is here taken is, you would say, well, how is it that my clients can say that the right to foreclose may be in dispute. And the answer to that is because there is a mandatory provision of applicable law which would entitle the arbitrator. It's not like force majeure and frustration, which is a blunt instrument, which is only a means to terminate contract for supervening impossibility. It is a provision that gives a jurisdiction to the court, or in this case, the arbitrator, to amend the terms of contractual agreements to deal with matters that have arisen of a public nature, including the financial crisis and presently the COVID crisis, and the fact that it is having presently a great impact on the ability of my clients to pay and on the value of the proprietary right, which is about to be forfeited. So that is the dispute.
Can I interrupt again, please? I'm sorry. You may or may not be right about this, but isn't the problem that none of this was raised? Orders were made, which Mr. Montague-Smith says are final orders and cannot be now changed by me on this application. Isn't that the problem you've got to face?
Indeed, Your Honour, if Your Honour is not persuaded that because of the change of circumstance, where I do disagree with him, there is one important fact which has been impossible to have been raised before. That aside, if Your Honour is not persuaded that the case management powers are ones that can be used after a final judgment, then one is into stay, permission to appeal, and all of that. Now, Your Honour, we may be criticised for saying that no application for permission was included in the existing application. What we sought to do, and it remains our case that the power does reside in the court, both under the inherent jurisdiction of the court and under the case management powers that have been given, to make these variations to the final order. If Your Honour is not so persuaded, then plainly I would be instructed to, one, seek permission to appeal this decision, and two, make an application for some modification to tomorrow's time limit so as not to render an appeal nugatory. But unless Your Honour would like me to take a different course, it seemed to me that rather than making any application now to seek retrospective permission to alter the application as made, is that it may be that Your Honour would wish to give judgment, and if I'm going to make any such applications, that I would have to on the assumption that Your Honour is going to give an extempore judgment, because we do have the difficulty that a property right would be forfeited tomorrow, absent something else. So I was concerned as a practical matter. I'm sorry, the last thing I should address is that if to the extent that an undertaking given to the court is not satisfactory in its existing terms, I will take instructions and have no doubt that my clients would sharpen that up. Your Honour will have noticed that the extension of the mortgage is a one-page, two sides document in English and Arabic in pretty much standard form. So it isn't as if anything, I think, has to be negotiated. And our concern was to maintain the registration and the priority unbroken, so that the claimant's security rights would not be prejudiced. And that was the purpose of the undertaking. Beyond that, Your Honour, I have nothing else in reply.
One thing that occurred to me when Mr. Montague-Smith was addressing his dissatisfaction with the undertaking was this: if by some agreement the duration of the mortgage is extended, might that have some effect on the guarantees? And if so, would it be necessary to have all guarantors join in that extension?
I would not, to my knowledge, Your Honour. I think there are two different considerations. One, which Mr. Montague-Smith raised, which is whether indeed it is the case that the effective foreclosure is automatically to extinguish the guarantee obligations, which would seem to me to be right.
That may or may not be so, but the point is that you are saying you would like an extension by agreement. If that happened, would that mean that the guarantors at the least would be able to argue, possibly successfully, that the guarantees had been discharged?
Not to my knowledge, sir, but I would need to, I mean, it's very sophisticated lawyering, and
there would be a change in the principal obligation. That normally, unless the guarantees cover the situation, which they commonly do, of course,
they do.
That would discharge the guarantors.
Well,
I have no idea if the guarantees cover that.
I'm not in the position to address, Your Honour, on all of the guarantees. As Your Honour has just said, it would be very common indeed that there would be language to the effect that the guarantor's obligation would be treated as if it was a primary obligation, and language saying that any indulgence extended to the primary obligor wouldn't let them off the hook. I'm not in the position here today to be able to take Your Honour to that language, but I would be extremely surprised if it wasn't there, and Emirates NBD or Mr. Montague-Smith may know the answer to that.
Anyway, thank you, Mr. Taylor. Anything else?
Not at this juncture, Your Honour, no, thank you.
Yes, thank you. Gentlemen, I'd just like to have just a few minutes to myself just to settle some thoughts, and then, as expected in the under the circumstances of urgency, I will give an extempore judgment, which may be less detailed and less well expressed than I would otherwise like. So please just give me a few moments. Yes, gentlemen, if you're still there, I will give my reasons now.
Thank you.
This is an urgent application filed yesterday for relief in relation to orders in a judgment issued on 15 June 2020. In the interests of time, I will not rehearse the judgment and orders, knowledge of which is assumed. The first element in the application is abridgment of time for its service. It was served on the claimant yesterday afternoon. The orders in relation to foreclosure have effect tomorrow. And the third element in the application involves extension of that time. Necessity drives allowing an abridgment of time.
I think we may have lost the judge again. All right, is that me?
Is the Major able to let him know that he's been lost, if he doesn't?
Are we back online?
Yes, we're here.
Mr. Taylor, are you there also?
Also here, Your Honour.
Thank you. I think it went out, as I said, the third element in the application. Is that where everyone has me?
Yes, that's correct.
Thank you. I'll continue from there. The third element in the application is amendment of the orders made on 15 June 2020. Amendment is sought in three respects. The first is that the date of 23 June 2020 in orders 1, 2 and 3 becomes 31 January 2021, the effect being that the foreclosure will not take effect tomorrow, but subject to prior payment or sale on the later date. The second is to include a proviso that the orders are subject to any further order of the court or of an arbitral tribunal under arbitration agreements said to be material to the claimant's claim. The third is to include an undertaking by the defendant to cooperate with the claimant to extend the duration of the mortgage to 31 January 2021 and register the extended mortgage, all by 30 June 2020. The first question is power to amend the orders made on 15 June 2020. There is no power to vary final orders unless they were obtained by fraud, which is not here suggested, and the claimant submitted that for that reason alone the application in its third element must fail. In the application notice, the defendant sought the amendments pursuant to the court's case management powers in Part 4 of the rules. At the hearing, that rather took second place to a submission concerning arbitration, which also explained the proviso, part of the desired amendments. It's convenient to go to that submission first. The defendant submitted that the documents restructuring the liabilities of the Al-Jaber Group included arbitration clauses displacing this court's jurisdiction to make an order for foreclosure in favour of an arbitral tribunal. It then relied on Article 13 of the DIFC Arbitration Law, Law Number 1 of 2008, by which if an action is brought in a matter the subject of an arbitration agreement, the court, quote, shall, if a party so requests not later than when submitting his first statement on the substance of the dispute, comma, dismiss or stay such action unless it finds the arbitration agreement is null and void, comma, inoperative, comma, or incapable of being performed, end quote. The defendant said in substance that it now requests and submitted that because a stay is mandatory, the orders made on 15 June 2020 were capable of amendment. It was not entirely clear, it was not fully spelt out why that was so, but as I understand it, the submission was that those orders should be regarded as interlocutory orders in aid of the arbitration. Being interlocutory, it was suggested the orders could be varied again as orders in aid of the arbitration, and the proviso was then in effect a recording and preserving of further orders of the court or of the arbitral tribunal and final arbitral determination. I will assume, contrary to the claimant's submissions, that the documents do provide for arbitration of disputes over enforcement of the mortgage, and that the claimant has not elected to litigate pursuant to a right to do so also in the documents. One reason, however, is sufficient to decline to accept the defendant's submission. When the orders were made on 15 June 2020, there was no enunciated dispute, and there was no request to dismiss or stay the proceedings. The court had jurisdiction and was not prevented from exercising it by any operation of Article 13. The orders then made were final orders and cannot be retrospectively converted into interlocutory orders in aid of arbitration under an arbitration agreement which the defendant did not invoke. I note, without it being necessary to deal with them, the claimant's other submissions to the effect that the documents do not extend to arbitration of disputes over enforcement of the mortgage, that enforcement of securities was carved out of any arbitral regime, that there was in any event not an arbitrable dispute, because making an order for foreclosure pursuant to Article 70 of the Real Property Law is reserved to the court. And finally, that the defendant is now too late to invoke the arbitration agreement and has waived any right it might have had to do so. I go then to case management powers. They allow an extension of time for compliance, which is not in point. They allow for stay of a judgment, which is not sought. What is sought is to vary the orders. The defendant referred also to RDC 4.2(14), by which the court may take any other step or make any other order for the purpose of managing the case and furthering the overriding objective, but that does not apply. The case is over. Final orders have been made. Even if the orders could be varied as sought, I would not vary the dates to 31 January 2021. The defendant submitted that it had interest from a potential purchaser of the property and wanted additional time to, quote, take into account, end quote, that party's interest. It offered the undertaking above mentioned as a means of avoiding prejudice to the claimant's rights when the present duration of the mortgage expired. the claimant submitted that there was no material change of circumstance and that the defendant was doing no more than seeking to litigate matters which it could and should have litigated at the earlier hearing. That may or may not be so. It depends on when the arrangement with the potential purchaser came into existence. Apart from that, I have reservations about the interest in purchasing the property. The defendant did no more than proffer a letter agreement dated 21 June 2020, that is, after the orders in relation to foreclosure, for the disclosure of information to the potential purchaser, with a term that for 3 months the defendant will not enter into discussions to sell the property to anyone else, and for a further 3 months will give the potential purchaser a right of first refusal. There is no evidence explaining the defendant's failures in promises referred to in the earlier judgment, or how the potential purchaser's interest came about apparently so recently, and I do not think it can be said that a real prospect of a sale has been shown. In addition to that, any extension must take account of the ending of the duration of the mortgage, as the defendant recognises by offering the undertaking. The claimant does not regard the undertaking as acceptable. In my view, that is correct. And an undertaking to cooperate is simply not good enough. Cooperation leaves room for failure, exposing the claimant to expiry of the duration of the mortgage with an argument over cooperation, and contempt proceedings in place of its present rights to enforce the mortgage. In addition, as the claimant submitted, extension of the duration of the mortgage might be open to challenge by other creditors of the defendant, to which I add may also prejudice the claimant's rights against guarantors, full stop. In the circumstances, it does not seem to me that a case has been made out for variation, even if there were power to do so. It follows that I decline to grant the relief sought in its third element. Gentlemen, that's the end. I think the formal orders would probably be an order
Your Honour, if I may, Mr. Taylor, and it may be that we missed it, or maybe there was, when you were cut off and you'll come on to the third point, I didn't hear, unless I'm mistaken, your ruling with respect to permission to file the acknowledgement of service out of time.
Very well, I'll repeat that in just a minute. Mr. Montague-Smith, did you hear that? Was that recorded?
I think, no, I don't think so. It may be that we were at cross purposes when you were discussing where you dropped off, Your Honour.
All right,
I think,
thank
Your
you.
Honour, that would have been your second point, and we
Yes,
picked up
yes.
earlier.
I'll repeat, I hope in much the same language, what I said about the second element, and that can be fed into the judgment when it gets recorded. This will appear after I made an order abridging the time for service of the application. The second element in the application is extension of the time for filing an acknowledgement of service. The defendant did not file an acknowledgement of service following service on it on 21 April 2020. Under RDC 8.16, in such a circumstance, a defendant may attend the hearing of the claim but may not take part in the hearing unless the court gives permission. In my view, it is sufficient in the present case for me to give permission to the defendant to take part in the hearing today, as it has, by making the application and making its submissions. And I do not think it appropriate to extend the time for filing an acknowledgement of service. That is because filing an acknowledgement of service carries with it the ability to state a position concerning arbitration, concerning jurisdiction, and to put forward a defence which the time for which has all passed, and I do not think that matters should be complicated by permitting those things to occur at the present stage when orders have been made, which, as will appear later in these reasons, I regard as final orders. That's the petition, gentlemen. And I was going to say that I think the formal orders to be made would probably be the order abridging time for service of the application to 5 p.m. on 21 June 2020, and that the application is otherwise dismissed. Does that seem to be the result?
Thank you, Your Honour, yes. And I'd also ask for my costs.
Yes. Well, first of all, Mr. Taylor, is that, would they be the appropriate orders, do you think?
I agree that those would be the orders made with obviously a schedule of reasons, and I can't resist Mr. Montague-Smith's application for costs in the circumstances. What I would wish to address
that the defendant shall pay the claimant's costs of the application to be assessed if not agreed. Would that do the trick?
Yes, thank you, Your Honour.
Mr. Taylor, would that be appropriate?
That would be appropriate, Your Honour, yes.
Yes, very well. I'll make that order as well. Well, where does that leave us? That, as far as I'm concerned, that's the end of the application. But Mr. Taylor, you have made mutterings about other things.
I have indeed, Your Honour. So in relation to appeals, it seems to me, Your Honour, permission would be needed with respect to, I think, 3 matters. One is, it seems to me, that the decision not to adjourn upon the request of the defendant was a case management decision made prior to the final hearing. There is then the judgment made as a final judgment for which permission would be needed. And finally, there would be permission for the refusal of today's application. And then there's the question of any brief stay and undertakings with respect to appeal in order for the appeal not to be rendered nugatory. In an endeavour to be as practicable as possible in the circumstances, the absolute deadline is the 30th of June, which is a week tomorrow, that any temporary stay that would be sought, and I can take Your Honour to the powers to stay separately in Part 44, would need to be just sufficient if Your Honour were to grant permission to appeal in order for the notice of appeal to be filed and an urgent application for the Court of Appeal to hear it, which would need, in my respectful submission, to be dealt with before the 28th of June. One is in very constrained circumstances, but what I would say, Your Honour, is that the effect of foreclosure would, if not render the appeal entirely nugatory if there was not a stay, because I believe there would be, it would be possible to appeal the substantive order to foreclose, but there is extreme urgency and extreme prejudice. And in my respectful submission, the matters that have been raised, both as to arbitral jurisdiction and the appropriate means to deal what, in my respectful submission, is effectively a defendant with no professional representation, are important matters that would need to be addressed. Of course, if Your Honour is to refuse permission to appeal, then any application, both with respect to permission and with respect to stay, would, under the rules, fall to be made on paper to the Court of Appeal. And I understand that Mr. Montague-Smith, who's most expert on these things, will correct me if I'm wrong, that the DIFC has now adopted the High Court, so that any refusal, grant or refusal of appeal on paper would be the end of the matter. So in my respectful submission, this is a case in which I would invite Your Honour to give permission to appeal. The question of whether and if any, what sort of stay should then be imposed by Your Honour would really turn in the first place on a decision as to whether to give permission to appeal, yes or no. And if I could invite Your Honour to rule on that first, and then hear whatever would appear to be appropriate in the light of that decision, because it seems to me that is, do you give permission, yes or no, arises first, and stay, and if so, the terms of any stay would arise dependent on what decision was made at that stage. Is Your Honour satisfied with that as an approach, subject to anything Mr. Montague-Smith has to say?
I'm not at all satisfied at this procedure, Mr. Taylor. I don't know what you want to appeal against. I don't know whether you're saying you want to appeal against the refusal of the adjournment. I don't know whether you want to appeal against the judgment of the 15th of June. I do not know what your grounds are. You haven't said anything about any of those, and I really do not see why I should participate in you making things up on the run. I'm sorry to be so blunt, but that seems to be what's happening.
I take no offence at your being blunt, Your Honour. There's a practical matter, which is that I must make an application to Your Honour first. If the matter's going to proceed, if Your Honour refuses permission, you refuse permission. I thought I had made it clear that I would need permission to appeal against all three: the adjournment, the substantive judgment, and today's.
Tell me your grounds, so that I know whether I will grant leave, or whether I might refer it to the Court of Appeal, which frankly seems to be a course which might be a better one, because the Court of Appeal can then manage any question of a stay.
Certainly, that would certainly be a course if Your Honour wishes me to address you further on the grounds for each of those heads of permission, as it were.
It would be nice to know where it's said I'm wrong.
So, with respect to the adjournment application, which would arise first, I would say that given that was a party that was not professionally represented, and in circumstances where the manner by which they should have, if they wished to rely on the arbitration agreement, was by filing the acknowledgement of service, that with an unrepresented defendant should have been taken as an application to extend time for the acknowledgement of service. So the question of whether they wanted to apply to stay for arbitration could have been made in the manner which, as Your Honour has said, it must be made and by filing an acknowledgement of service. And it's because it must be made in that way that Your Honour has not granted that head of today's application. So that would be the adjournment.
I'm sorry, would you mind just repeating that? Is the error that the court did not of its own motion say, oh, you should be objecting on the ground that there's an arbitration agreement? Is that the error?
No, that's not the error. The error was that it was a case management decision which had the effect of depriving the claimant, the defendant rather, of the opportunity to make a challenge to jurisdiction based on its assertion of the arbitration agreement. So that in terms of case management appeals, there's the high standard that one had to overcome, which is to show that it's 4426, where I think that 4426, 3 directions about the timetable of the claim probably makes the timetable of hearing a case management decision. And in order to get permission, the lower court or the appeal court deciding that application may take into account whether the issue is of sufficient significance to justify the cost of appeal. And that is
what is the ground of appeal? Enunciate it, please.
So in relation to the case management decision, is that you erred in your case management discretion not to give time for the defendant to secure representation, which would have enabled them to have made the case that this should have gone to arbitration, and therefore thereby avoid the forfeiture of their valuable real estate.
Right. Well, I do not think there is any reasonable prospect of success on that, so I'll refuse leave on that ground. So we move on then to the 15th of June judgment.
So the 15th of June judgment is that by being deprived of an opportunity to be represented, there was no opportunity for a substantive argument to be made on the question of whether the foreclosure rights had arisen having regard to the hardship to which the defendant was subject. The defendant would have had obviously to have put in evidence of that, and I say in the time available there is no evidence before Your Honour today, by which you can assess the merits of that. I have tried to explain why, as a matter of mandatory applicable law, regardless of whether it be in arbitration or for Your Honour, that is a matter that ought to have been considered.
Would you mind framing the grounds of appeal?
So, in essence, the adjournment decision, the case management decision and the substantive appeal fall to be taken together. Just 1 second, Your Honour. And indeed, you're quite right. Your Honour, the decision that you took with respect to jurisdiction was under 5A 1B of the Judicial Authority Law, and it was foreclosure 5A 1E, which is essentially real estate within the DIFC and the specific remedy of foreclosure. Now, as Your Honour has said, it is not a question that the court lacked jurisdiction, but it was jurisdiction which it ought not to have exercised. It's difficult to disentangle the case management decision from the substantive decision on jurisdiction because one flows into the other. Had the opportunity been afforded for the point on jurisdiction to be taken, it would have been an error in exercising the jurisdiction which you had. If jurisdiction arose at all, it would have been ancillary to the arbitration. That would have, as explained in the skeleton argument, called into the question whether the court had a power to intervene under Article 10 of the DIFC arbitration law, which is model law and says that the court shall only intervene as provided in this part, and the provisions with respect to interim relief are provisions that are exercisable on the face of it only with respect to arbitrations seated within the DIFC and not outside. So that's how the case management appeal and the substantive appeal would fit together, as it were, Your Honour. That would leave only today's decision.
I'm sorry, I do want to understand. I really did not understand what you were saying. We start off when you want to appeal against the 15th of June judgment that an adjournment was refused. So one then looks at the judgment in its own right. And what I would like to know is what your grounds of appeal are in saying that in its own right there was error.
The error, Your Honour, would have to be the failure to take into account the provisions of Article 249 of the Civil Code, being a mandatory provision of applicable law, that it cannot be excluded by contract, giving the power and discretion of a judge to, having weighed up the circumstances and the interests of the parties, to reduce onerous obligations. That's what would have been.
So the error was failing to take that into account when no one asked that it be taken into account.
I appreciate that. In essence, since they were there, that has to be that. That's why I say I appreciate why Your Honour is dealing with the case management decision and the substantive decision separately, but in the circumstances which have arisen and in relation to the overriding objective and the basic premise that the law shouldn't effect injustice, it's very difficult to disentangle the two.
Yes, thank you. I think I follow, but I would not grant leave to appeal on that in relation to the 15th of June 2020 judgment either. I don't think there's a reasonable prospect of success. That decision almost follows inevitably from what I've said in relation to adjournment, I think.
Your Honour, I think it does look like that.
Yeah. So we get to today.
So we get to today, Your Honour, that the ground of appeal would be one, that the inherent jurisdiction of the court to vary was available, because that's the jurisdiction of the court. Two, that the case management powers in view of the form of order were ones that could be exercised, and that whether that simply because the application didn't put that in terms of an application for stay would not be a good reason not to give the equivalent relief as a case management power.
Okay, I understand, thank you. But I regret to say that, again, I don't think there's a reasonable prospect of success on that either. So I would not grant leave to appeal on that either. Mr. Taylor, you made a remark earlier which made me think that you considered that that's an end to the matter. I don't think it really is. I should remind you that you have the opportunity to, following my refusal of leave, to apply to the full court. I don't want to wish this upon the full court. I just remind you that on my understanding of the rules, it is there.
Your Honour, yes, and I think in the circumstances of your refusal of permission to appeal, that the appropriate way to proceed would be that any application, both for permission to appeal and for a stay, would be on paper to the Court of Appeal, and therefore there's no need to trouble you further now.
Yeah, that's a matter for you. I think that my part is now concluded.
It is, sir, and I'm grateful.
Mr. Montague-Smith, is there anything you want to say in relation to what has passed?
I don't think there's anything. No, I don't think there's anything for me to add. We'll obviously wait and see what happens next. But as you say, Your Honour, it sounds like your part in this is come to an end.
Very good. All right then. Well, if there's nothing else, gentlemen, then I will simply thank you for your assistance, and I will leave you to what may or may not be another round.
Thank you, Your Honour.
Thank you, Your Honour. The only thing I would say, and I'm sure, is that the registry would be extremely cooperative in obviously getting Your Honour's judgment and order and reasons drawn as soon as possible, which would be grateful if Your Honour is available to look at that draft.
I'm sure they will, but if it makes any difference, I would certainly ask the registry, because you will need these materials, and indeed preferably the transcript of today, as soon as possible for your future steps, if any.
I'm grateful, Your Honour.
Thank you very much. In that case, I will say what is, from my point of view, good night.
Thank you, Your Honour.